Hi everyone and welcome back to another video. Now back in January of 2024 I posted this video where I talked about some of the tweets posted by former footballer Joey Barton. Now since then Joey Barton was charged with 12 counts of sending an electronic communication which was grossly offensive contrary to section 1 of the Malicious Communications Act of 1988. Now these charges relate to messages posted on social media about female football pundits Ene Aluko and Lucy Ward, as well as TV presenter Jeremy Vine. And on Friday the 7th of November of this year, Barton was found guilty of 6 of these offences and was acquitted of 6 more, and is due to be sentenced on the 8th of December. Now in this video I'm going to go through the facts of this case. I'm going to explain the law behind section 1 of the Malicious Communications Act 1988. I'm going to talk about the freedom of speech laws that exist in the UK, and then I'm going to end by talking briefly about sentencing for this kind of offence. Welcome to my channel, Andy on Crime, where I talk about high profile criminal cases and other aspects of criminal law in England and Wales. And if you want to follow me on other social media channels, I am on TikTok. My handle is AndyOnCrime1, and I'm also on Twitter or X, and my handle is AndyOnCrime. If you would like to support my channel, then you can click the link in the description, or there should be a link above, to sign up with NordVPN, where you can get a huge discount on a range of their plans. And by doing so, you will be supporting my channel. So thank you. With all that being said, let's get into the video. So starting off with the facts behind this case, between early January and mid-March of 2024, Joey Barton posted a series of messages on the social media platform X, formerly known as Twitter, which was directed at 3 public figures, which were Ene Aluko and Lucy Ward, who are female football pundits who commentate on the men's game, and broadcaster Jeremy Vine. These messages included comparing Ene Aluko and Lucy Ward to the serial killers Fred and Rose West, including producing a superimposed image of their face on the bodies of Fred and Rose West, made posts about Ene Aluko implying that she was only there to tick boxes, and he made posts about Jeremy Vine where he called him a bike nonce, which to any non-UK viewer that means he's calling him a paedophile, asking if he'd been on Epstein Island and whether he was in the flight logs, and saying that people should phone the police if they saw Jeremy Vine near a primary school. Now, the case was investigated, or the tweets were investigated by the police, and the Crown Prosecution Service authorised 12 charges against Joey Barton of sending a grossly offensive electronic communication with intent to cause distress or anxiety. On the 14th of March 2025 at Liverpool Crown Court, Joey Barton entered not guilty pleas to all 12 counts, and the case went to trial. Now, during his trial, Joey Barton argued that he was the victim of a political prosecution, and that his comments, which were aimed at football pundits Ene Aluko and Lucy Ward, were simply dark and stupid humour. And he said he'd been trying to make a serious point in a provocative way. Now, Barton at the time of posting had over 2.5 million followers on X, also claimed that the posts in relation to Vine were merely crude banter, and that in using the phrase bike nonce, he had never intended to imply that the presenter was a paedophile. Now on Friday the 7th of November 2025, a jury found him guilty of 6 of the 12 counts. He was found guilty in relation to 2 tweets against Ene Aluko and Lucy Ward, and not guilty on the other 4, and he was found guilty on 4 of the counts in relation to Jeremy Vine, and not guilty on the other counts, and he's due to be sentenced on the 8th of December 2025. So now diving into the law behind this case, and as you'll probably be aware, there's a large number of criminal offences that can be committed using social media, and you'll have probably seen cases where people are being prosecuted, for example, for making racist comments towards footballers, or inciting violence, even threatening violence to other people. But where do Joey Barton's tweets fit into the criminal law? Well, under section 1 of the Malicious Communications Act of 1988, it is an offence for a person to send an electronic communication such as a tweet which conveys any of the following: a message that is indecent or grossly offensive, and the sender's purpose must be to cause anxiety or distress to the recipient. So all of this is capable of being achieved through a tweet or a post on Facebook or other social media. Now, the threshold for establishing that a communication is grossly offensive is necessarily high due to the potential impact of freedom of expression under Article 10 of the European Convention on Human Rights. So this, in theory, aims to avoid punishing people unnecessarily or for setting the bar too low for what should be banned. Now, the fact that a communication may be in bad taste or controversial will not necessarily be sufficient. And indeed, in this case, before the jury retired, the judge told the jury that the term grossly offensive required a high bar for conviction. And the judge said the following: the criminal law is not there to punish bad manners, sharp humour, or unpopular opinions. The law only intervenes when the content is of such an extreme, degrading, or dehumanising character that society as a whole would say, that goes too far, that crosses the line for what we can tolerate. And on 6 of the charges that Joey Barton was charged with, that's what the jury was sure was the case, resulting in him being convicted of those 6 charges and acquitted of the other 6. So I know as a result of this conviction, there will be viewers on my channel jumping up and down saying, well, what about free speech? Does that mean that you cannot say anything anymore? Does that stack up? Well, the UK, unlike, for example, the US, does not have a written constitution. So whereas freedom of speech is enshrined in law in the US under the Constitution, there is no such thing in the UK. Our constitution is what is known as uncodified, meaning it comes from several sources as opposed to one written document like the US Constitution, for example. So does that mean that we have no freedom of speech? Well, no, not exactly. Under the European Convention on Human Rights, which has direct application in the UK due to the enactment of the Human Rights Act of 1998, we have freedom of expression covered under Article 10, which states, everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television or cinema enterprises. The exercise of these freedoms, since it carries with its duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society in the interests of national security, territorial integrity or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, and for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. Now, some of the rights under the European Convention on Human Rights are known as absolute rights, meaning that there can be no limitation on that right by the state. Article 3, for example, states that no one shall be subjected to torture or inhumane or degrading treatment or punishment. There is no qualification or limitation that can be imposed by the state under Article 3. Freedom of speech, as you may have noticed, does have qualifications or limitations that can be imposed by the state. So freedom of expression is known as a qualified right. So if you, for example, are promoting violence, then that is clearly not protected by Article 10 and you've no right to claim freedom of expression. In this case, the law as it currently exists means that your freedom of expression does not extend to sending messages which are deemed grossly offensive. And it's also worth pointing out that there's been no new laws passed by the new government which are now being used to prosecute people. These laws have existed for quite a while now. The facts as they exist in this case were that the Crown Prosecution Service considered the evidence in the tweets and then decided that the legal tests which they apply were met for charging Joey Barton with 12 counts of sending an electronic communication that was grossly offensive, intending to cause anxiety or distress. Joey Barton, for his part, denied the charges and went to trial. The jury ultimately found that 6 of the messages constituted grossly offensive messages and found that 6 of them did not. Hence, he was convicted on 6 charges and acquitted of 6 other. So what do you think about these limitations on freedom of expression? Are they an affront to society, or are they necessary to ensure that carte blanche is not given to say whatever you like? Please let me know in the comments down below. The final thing that I want to talk about is sentencing. Now, I'm not going to talk about Joey Barton's case specifically as proceedings are ongoing, but I'm going to talk about the sentence that he has been convicted of. Now, the maximum sentence for this offence is 2 years imprisonment and or a fine. Now, there doesn't appear to be any specific sentencing guidelines as there are for, say, battery or robbery. So what will likely happen is that the judge will be guided by case law, so looking at comparable cases for this offence and seeing what determinations for sentence were made in there to inform the decision in this case. Now, as the maximum sentence is 2 years, any sentence that's greater than 14 days but less than 2 years is capable of being suspended for up to 2 years. If that happens, then someone will be subjected to conditions and likely have to undergo some unpaid work or rehabilitation requirement for a specified period. If the person fails to comply with the requirements of the suspended sentence order, then they can be brought back before the court, where the judge can consider whether to activate the sentence in part or in full, and they'll be guided by things like how long have they gone through the suspended sentence order and how well have they complied with the requirements. Ultimately, we will find out on the 8th of December. So to summarise, Joey Barton was charged with 12 counts of sending an electronic communication that was grossly offensive, intending to cause distress or anxiety. He was convicted of 6 of the 12 charges, acquitted of the other 6. One of the charges was against Enia Luco, 1 was against Lucy Ward, and 4 were against Jeremy Fine. He's due to be sentenced on the 8th of December. And we talked about the offence of Section 1 Malicious Communications Act 1988, that requires the term grossly offensive, which has a high bar due to the requirement not to punish people unnecessarily. I then talked about the balance between freedom of expression and the fact that that is a qualified right which can be or have limitations imposed on them by the state, such as in this case where Section 1 of the Malicious Communications Act exists. And finally, it talked a bit about sentencing, where the maximum sentence is 2 years and any sentence less than 2 years is capable of being suspended. Ultimately, as I said, we will find out what the sentence is on the 8th of December. Thanks for watching. If you did enjoy this video, then please do give it a like. If you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.